Welcome to Law Sessions. I am Jennifer Housen. In this session of land law, we will be covering easements, and in particular, we will consider what is an easement, how it is created, and we will also consider how it is protected. When you consider easements as a topic, and indeed if you are going to approach this sort of question in an examination, you need to ensure that you approach this question in a structured manner. You approach easement questions on the same basis that you approach leases and licenses type questions, meaning you first look at whether the essentials are in place. Secondly, you look at whether or not the right has been created. And lastly, you look at whether the right has been protected in order to see whether or not it will bind a third party. Now, most times persons have some difficulty with easements, not least because they consider that it is slightly esoteric and therefore not something that they are likely to encounter or quite fully grasp. I hope that over this next hour or so, it will obviously become slightly clearer to you, and indeed so clear that you can indeed tackle it on an exam paper. Now, the first thing is to consider what is an easement. Well, an easement is no more than a right to use a person's land for the benefit of another piece of land. That definition is important because just because you use somebody else's land does not make that use an easement. It must be that your use is because it benefits the land from where you are. So, for example, if you have a right granted to you to walk over Blackacre, say, then that is called a right of way. Equally, if you have a right to lay a drainage pipe over Blackacre to stop Whiteacre flooding, then that is also an easement because you are using Blackacre to run the pipe over in order to stop Whiteacre, another piece of land, from flooding. So if you imagine that you have to cross over your neighbor's land to get to the main road, for example, if you want to use a track for that purpose, that will also amount to an easement. Now, as I said, this is all about structure. And the structure is, as you look at any problem question, and the vast majority of land law exam papers will tend to be made up of somewhere in the order of 6 or 7 problem questions with maybe 1 or 2 essay type questions. So it's highly likely that an easement question will manifest itself in a problem. So what you need to do first of all is to consider whether or not the right or rights that are set out in the problem amount to the essentials of an easement, or also known as the essence of an easement. And the essence of an easement are these: that the requirements as laid down in the case of Real Ellenborough Park are met. And there are 4 requirements in Real Ellenborough Park. They are that there must be a dominant and a servient tenement. The dominant and servient tenements must not be owned and occupied by the same person. That is, of course, diversity of occupation. So it must have different owners and occupiers. Thirdly, the right must accommodate or benefit the dominant tenement, and we will see why that is in a minute. And the last requirement, of course, is the right must be capable of forming the subject matter of a grant. Now, as it relates to forming the subject matter of a grant, this last heading has 4 sub-requirements in that there must be a capable grantor and grantee, the right must be sufficiently definite, and the right must be analogous to existing easements, as well as it must not totally exclude the servient owner, because if it does, arguably you're looking at some type of adverse possession or squatter's rights. Now, there are certain type of rights which have been held to have been capable of being easements. So a right of way, for example, Borman and Griffith says that that amounts to an easement. The right to lay and maintain drains and sewer pipes have been held in the case of Simmons and Mitford in 1969 to be capable of forming an easement. The right to store or the right of storage Wright and McAdam in 1830 say this very well can amount to sufficient to be capable of forming an easement. And the right to support a connecting wall in Richards and Rose, the court says that can amount to an easement. Now, an interesting one, of course, is in Miller and Emser products in 1956. The court said that the right to use a toilet could amount to an easement. Now, if you consider, for example, a right to light, that is not capable of forming an easement, because what is light, for example, a right to a view? What you can get as an easement, though, is a right to sufficient light in order for you to be able to reasonably use the building. And the case for that, of course, is Coles and Home and Colonial Stores. Now let's look at each of those at the moment. Those four requirements, as under Real and Borough Park, there must be a dominant and a servient tenement. Well, what is a tenement? A tenement is simply an old name for a piece of land in which the owner has a legal estate. All it does is give a definition of what land is. That is what it means by a dominant and a servient tenement. So you could simply say there must be a dominant land and a servient land. Now, the dominant tenement is the land which has the benefit of the right claimed. So, for example, if we start off with an example of a right-of-way, let's assume that Blackacre is owned by A. Let's assume that next to Blackacre is Whiteacre, which is also owned by A. And let's assume, for argument's sake, that A sells Whiteacre to B, and B has to walk over Blackacre to get to the main road. Well, the dominant tenement is the land which has the benefit of the right claimed, which would be B's land, which is Whiteacre, because the right-of-way is leading over to get him to Whiteacre. So Whiteacre would benefit from the right-of-way. The servient tenement is the land that the right is exercised over, which has therefore to bear the brunt or the burden of the right. And that, of course, in our scenario, would be Blackacre, because the right-of-way is across Blackacre. Now, the dominant and the servient tenement must not be owned and occupied by the same person. And the simple rationale for this, of course, is that you cannot have an easement over your own land, in that you cannot have a right against yourself. The next thing is that the right must accommodate or benefit the dominant tenement. So the right is a land law right. It is benefiting the dominant land. It is not just a right that benefits the owner of the dominant land in his personal capacity. And the case, of course, that puts this clearly into light is Hill and Tupper, where in that case they held it to be of a personal benefit as opposed to a proprietary or property right benefit. So, for example, if you say to me that I can come over and use your swimming pool whenever I liked, that is benefiting me personally. It is not benefiting me as it relates to the land that I occupy. The next thing, of course, is that the right must be capable of forming the subject matter of a grant. And simply that says that all easements must be capable of being granted expressly in a deed, meaning the right that you're seeking to have must be able to be placed in a deed. The satisfaction of the following four requirements, though, will meet that final condition in Real and Borough Park, and it's that there must be a capable grantor and grantee, and simply all that means is that the persons are of sound age and mind, so they're at least 18 years old. The grantor is the person given the right. The grantee is the person receiving the permission or the right. The second requirement under that fourth head is that the right must be sufficiently definite, in that you must be able to define the right that you're wishing to claim as an easement. If you can't say what the right is, you won't get it. Simply, if you can't say what, for example, a view is, because if somebody says, right, I have my property and my next door neighbor has come and built something right in front of my window that looks out onto the sea, well, has he obscured my right to view? Well, not necessarily. He's obscured your right to view the sea perhaps, but you now have a view. You have a view of the back of his house. And it is really that simple. And you cannot define that type of right, which is why if you can't say what it is, then of course you won't be able to prove someone is preventing you from using the right that you have. Of course, these will form the basis of the type of right that you will have. When you consider, for example, a right of way, you can define where a path runs, and that is clear enough. But when it comes to a view, for example, or light, that will be a little bit more difficult. The right must be analogous to existing easements, and what that means is that it must be similar to an existing easement. So it is not a situation where you can create a new easement. There must be an easement that you can pull the right you're seeking to rely on into that heading. So the easement must already exist in law or be recognized in law, and what you are claiming must be similar to that. So a right of way is capable of being an easement, and that has been recognized, as we said earlier, in the case of Borman and Griffiths. The idea then is that you cannot create new types of easements, and in the next section what we will consider is where the rights or how your rights can be considered in terms of easements, and the fleshing out really or expanding on what Ralenborough Park requires in terms of easements.